Welcome to everyone around the globe. Thanks for attending this webinar today on GDPR and CCPA. This is a joint presentation today from Thomson Coburn here in the United States and Charles Russell Speechlys in the UK. Today we're going to look at two primary sets of privacy requirements to see some similarities and differences between them. Consider how your preparations for one of these sets of requirements may help in your preparations for the other, and to think about where GDPR, being further along in the process, may help us to interpret CCPA, kind of understand the intentions there. I would note that although all three of our speakers here are attorneys, and maybe your attorneys, we're not acting as your attorney today, or at least for right now. So we're not giving legal advice. This allows us to be freer with our thoughts and observations, and so I think it's better for everyone. Before we begin, I wanted to cover a few household items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or if we run out of time, we'll answer it later by email. A copy of today's slide deck is available in the resource widget. You can find additional answers to some common technical questions located in the help widget at the bottom of your screen. In the U.S., the webinar is CLE accredited in California and Illinois for 1.0 general credits, and in Missouri for 1.2 general credits. We award the CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement, and your certificate of attendance will be emailed to you later this afternoon once your attendance has been verified. We value your opinions and appreciate your participation in the course today. So with that, we'll move on to presenters. I'm Jim Shreve. I'm chair of the cybersecurity practice here at Thomson Coburn. I've been working on privacy and cybersecurity issues for about 20 years. I work with companies in many sectors, including financial services and fintech, higher education, energy, technology, healthcare, retail, and others. I'm a big believer in learning from others. I think it allows us to learn without making mistakes. And so I think it's good to look at other industry sectors and other jurisdictions to see how they've addressed some of the same issues we may be dealing with ourselves. And with that, I'll pass it off to my colleague, Luke Sosnicki, to introduce himself.
Well, hello, everybody. My name is Luke Sosnicki. Thank you very much for joining us this afternoon or this morning, depending on where you are. I'm a partner in Thomson Coburn's Los Angeles office. I'm a litigator. I've spent most of my career litigating on behalf of various financial institutions in state and federal courts across the country, and that includes consumer claims and various types of business disputes. I also have an active practice advising not just financial institutions, but other entities on privacy issues, and specifically the litigation and regulatory risks arising from data management, data collection practices, including under California's new regime under the CCPA. So thank you again. Johnny?
Thanks, Luke. My name's Johnny McDonald, and I'm a partner with Charles Russell Speechlys in their London office. So we're an international law firm headquartered in London. We've got offices obviously in the UK, Europe, Asia, the Middle East, about 170 partners and about 500 lawyers all in. And within this firm, I head up the data protection and privacy practice group, leading that from London. Similar to the other two presenters, I've got quite a broad sectoral focus, technology, obviously, sport, FS, advertising, pharma, and I advise in relation to all commercial and non-commercial, so some contentious issues in relation to data protection and privacy. and that's me.
Good. Thanks, Luke and Johnny. What are we going to discuss today? Here's a basic overview. So much of what we're going to discuss involves fundamental aspects of GDPR and CCPA, how they're similar in some ways and important ways that they may differ. We're going to look at how our understanding of one standard, particularly GDPR, can help us understand the other. We'll also use a basic case study to kind of illustrate the scope and compliance issues under both GDPR and CCPA. And we'll close, hopefully, by taking some of your questions, which we encourage you to submit through the Q&A widget as we go along. Time permitting, we'll address the questions here, but if not, we'll address them later by email. So, that being said, let's get into the basics. What are GDPR and CCPA? And I'll pass it first to Johnny.
Brilliant. Thanks, Jim. A really helpful introduction there. I think that's a good place to start. Just very briefly, some of these more basic points. So I'll cover these first 2 points on this slide quite briefly and then talk a little bit about geographical scope of the GDPR, which is arguably a slightly more complex area than these two first bullet points. So before we talk about what the GDPR specifically does or what it was designed to do, probably useful to take a very brief step back and look about what European and UK, which come at this from a similar policy approach, what they're designed to do. So the right to privacy has been and is recognised as a fundamental right under European law. It's very important to Europeans. I suppose a similar way, chatting to my co-host the other day, you might draw the analogy with the right to free speech in the US. So with that in mind, the GDPR is really part of a privacy framework that gives rise to that fundamental right. So then if we look at the GDPR itself, which obviously entered into force in 2018, this was not a new revolutionary piece of legislation. It was a development on what we already had. And in some respects, it was designed just to simply update the digital age, laws that had been designed 20 years earlier when, before Google was even established, before Facebook was even thought of. So it's designed to update some of those laws and to harmonise them as well. Turning now to what type of business it applies to, this is probably one which we can deal with very briefly, because unlike the CCPA, which obviously Luke and Jim are going to talk about a little bit more, it's a slightly different beast. It is just far wider than that. It is designed to have an overarching regulatory approach. It governs everything. It doesn't matter what type of business you are, what type of entity you are, as long as you're processing personal data, then you are largely caught by this, subject to some very, very minor exemptions, the household exemption, which is really just to prevent you being caught when you're doing things with your own phone. If you're sending a message to your friend on WhatsApp and then you lose your phone, nobody can sue you and take you to court for a data breach. So a very narrow exemption. Other than that, it applies. There are no other thresholds. Turning briefly to the issue of territoriality before I hand over to Luke and Jim. So this is where the GDPR is slightly trickier, because it does have extraterritorial applicability. Now, in general terms, the GDPR is designed to catch you. It's designed to apply if you have one of two links to the EU, to Europe. The first one, which is now known as the establishment criteria, means if you're within the EU, have an establishment within the EU, you are caught. You are subject to its requirements. The second criteria, which is known as the targeting criteria, or the goods and services criteria, is more of an extraterritorial limb. And what that says is if you're providing goods or services into the EU, so if you're targeting consumers on that basis, then you're caught as well. And this will be important in relation to some of the things which we'll talk about a little bit later on. Luke, Jim, to hand back to you guys.
Thank you very much, Johnny. So the CCPA is similar in some respects, and obviously in some respects it's a little bit different. The key difference is one of the key differences is the territorial application. So unlike the EU, which approached the issue comprehensively, the United States at this point is doing it piecemeal. So California is the first state, and we'll get into it a little bit later as to what other states are doing, but so far California is the first state that's implemented this type of legislation, and it is designed to apply specifically to Californians' information and California consumers. So very broadly, the statute covers personal information of California consumers, both defined very broadly, personal information defined to include basically anything that can be reasonably used to identify an individual, and a California consumer basically defined as any California resident. So in terms of what it's intended to do, it's intended to cover a specific personal information about a specific subset of the U.S. population. Its key purpose, kind of going back to its roots as a ballot initiative, is really to give California consumers some visibility and some amount of control over the personal data that companies collect about them, and we'll get into a little bit later what certain of those rights are, what the obligations are on covered entities. It's also a little bit different than the GDPR with respect to the entities that it covers. So the scope of the CCPA with respect to the covered entities is not limited to territory. What it's limited by is doing business in California. It is limited to for-profit entities. So nonprofits at this point are not covered by, by the statute. So if you're doing business, and if you're a company and you're doing business in California and you're collecting the information of California consumers, you might be covered. There are also specific criteria, unlike the GDPR, that you have to satisfy to be a CCPA covered entity in the first place. You have to either have revenues in excess of $25 million, and it's a bit unclear, but the general interpretation is that's not California specific. It's worldwide revenues of over $25 million. Or you collect the information of 50,000 or more California consumers, households, or devices. That criteria also qualifies you for coverage. Or there's a third criteria relating mostly to the data broker folks, which is if you derive more than 50% of your revenue from the actual sale, defined somewhat broadly, but if you derive more than 50% of your revenue from the sale of California's consumer information, then you'll also be covered under the statute. So it's a little bit different. It's a little bit more, discerning in terms of its coverage than the GDPR.
And if I could chime in here just briefly, CCPA uses the term consumer frequently through the statute, but the way that term is defined is a little different than what you might be used to in other contexts. Quite often, if you're a financial institution, consumer means someone who obtains a financial product or service for personal, family, or household purposes. GDPR CCPA doesn't have that limitation on consumer. It just looks to if you have an individual who qualifies as a California resident. So I think that's something important to keep in mind here when we're looking at CCPA. What are a few other things then that we want to understand? Key things about GDPR and CCPA. Johnny, do you have some things here?
Yeah, thanks, Jim. To kind of continue that theme, I think because the GDPR is so much wider, it governs everything, things like employees and stuff like that, but the CCPA doesn't. So it's probably important to focus on a few key things that are comparable and which you can contrast. So to understand that, a few important background points really for those unfamiliar with European law and an EU type regime to consider. So the first one being that you require a lawful basis for processing under EU law, which is a concept which doesn't necessarily make sense if you're not familiar with a regime like this. So if you think about the GDPR, it's so broad, it's all-encompassing. It doesn't necessarily, in a particularly prescriptive way, it does in a few areas, but on the whole, it doesn't in a prescriptive way dictate to you how you need to comply with its obligations. It's principles-based for a start, so it's fairly high level. What it wants businesses, what it wants data controllers to use that EU terminology, is it wants them to take a risk-based approach. It requires them to think about the risks to privacy, to an individual's privacy, before it undertakes a particular activity. One of the ways it does this is it requires you to have a think about, in advance, a lawful ground for processing. There's a closed list and you need to be able to pick one. And this is important in the context of some of the things we'll be talking about in a little bit. As I say, there's a closed list. One of them is consent. So you might say, okay, well, I asked Johnny for his consent to send him direct marketing materials, and I needed to process his data in order to do so. He consents and I can do that. That's one lawful basis. Another might be that it's necessary for the performance of a contract. Johnny wants me to send him goods to his household address, then I obviously need to process his address. So it's important to have that as a kind of background. Next bullet point on the slide, and this is a bit of a kind of an eclectic mix of points here, but all things which are important to understand as we continue to talk about how the EU law applies and contrasts, is that the GDPR introduced an accountability principle. Now, what this means is it is a requirement to be able to demonstrate compliance. Now, a nice analogy to use there, which is one which I use not infrequently and certainly did when I was explaining this in the run-up to the GDPR entering into force, this idea of an accountability principle. If you use the analogy of being stopped by the police when you're driving your car, you might say, well, look, officer, car's insured, I've got a license, what's the problem? Tell me why I was driving unlawfully. And you'd expect them to tell you or to let you get on your way. Now, under the GDPR, with this accountability principle, we've got a slightly different situation. Now, the police officer or the regulator, in this case, might say, okay, well, I may or may not have seen you doing anything unlawful. You've got 20,000 miles on the clock. I would like you to demonstrate to me how you have been driving lawfully. You've got children in the car, show me your risk assessment, show me that you've thought about that and you put measures in place to ensure that they're safe. So this idea of accountability, which is important. And then the third point which I wanted to draw out is the fact that on top of the GDPR, and much as I've said that there is this one all-encompassing law which governs all areas, we have what's known as a lex specialis, so an extra layer of regulation that specifically deals with electronic communications. And this is known as the e-privacy regime. We have a directive at the moment, possibly going to a regulation in the future. So an e-privacy. And this deals with lots of things in that sphere in relation to electronic communications. But something which is particularly key and probably useful to contrast with the CCPA, because it essentially tries to achieve some of the same things the CCPA does, but in a slightly different way, is it governs electronic direct marketing. So if you want to send a direct marketing message to somebody, it governs how you do that. And one of the key things it says is that essentially you need to obtain consent in order to send somebody an electronic marketing message, in order to send them a marketing email or a marketing text message. It's an anti-spam provision. So take a step back, GDPR, you need to find a lawful basis for processing. Consent is one, there are others. Look at the e-privacy regime. What this then says is, okay, but in relation to direct marketing, consent is the only lawful basis on which you can rely. Now, there's an exception or an exemption called the soft opt-in, which enables you to send direct marketing messages to existing customers as long as it's coming from you, the sender, and it's in relation to similar goods and services. But this is an important issue to bear in mind, which has some, as I say, it has some similar aims to some of the CCPA stuff. Jim,
thanks, Johnny. Yeah. About the CCPA, I think historically in the U.S., the privacy focus has been on giving consumers notice about an entity's privacy practices, and then sometimes requiring consent for certain sharing of personal information. As Johnny indicated, Europe has obviously been different, with more regulation on what personal information can be collected and then how that personal information can be used by the collecting entity. I certainly believe that certain aspects of CCPA reflect some movement towards the European model, although obviously well short of GDPR in this respect. So I think the CCPA is important as a milestone in maybe changing the focus of U.S. privacy efforts. Historically, California also has been a leader on privacy in the U.S. and in some cases globally. You can look at the whole idea of online privacy notices, which were introduced by the California Online Privacy Protection Act. Many years ago, California had the first state breach notice law and is the basis for all other such laws in the U.S., which now all states have them. And because of its size and because of the likelihood of companies anywhere of interacting with California residents, these California laws often become an effective national standard in the United States and then can be a model for other states, as we saw with the breach notice laws. I think that's very likely to happen here, and to some extent we're already seeing that happening with events in other states that Luke will get into a little more here in a bit. So some of the key issues, some of these elements of the requirements. So there's we go into four topics here that exist in both GDPR and CCPA to some extent, but may differ a bit in how they do. And so I'll talk about the first one here. So notice. There are 4 required notice provisions within CCPA, and these are primarily described in Section 304 of the California Attorney General's Office's proposed regulations for CCPA, which they're required to issue. First of all, there's a privacy policy required that describes personal information that's collected, certain personal information sharing practices, and the specific California privacy rights that state residents enjoy. There's a requirement to give notice at the point of or prior to collection of personal information. Now, the way this is commonly being done, at least in an online setting, is providing a hyperlink to the privacy policy that's required, and then including within that, the substance that's required in that notice prior to collection. When you're doing this in an offline setting, this can be a little trickier. You may have to hand out something to someone who's giving you information in person, or give that notice verbally. CCPA also requires notice about the sale of personal information, and this is one of the unique aspects of CCPA. So if you're going to sell personal information, you have to tell consumers that, and you have to give them a right to opt out of that sale. A lot of entities may say, "Oh, we're not selling information. We're much more limited than that in our sharing." And I would say, definitely look at the definition of sale under CCPA, because it's much broader than you'd think. If you're sharing and receiving anything of value for that sharing, it could be deemed a sale. So be careful there. Definitely look at the statutory provisions that define that sale. And then the fourth type of notice under CCPA is notice where you're offering a financial incentive or price difference for the sharing or use of someone's personal information. This is a provision that I would say to this point hasn't gotten as much notice in many quarters. It's gotten a lot of notice in certain areas of marketing. but this is a somewhat unique part of CCPA. And so I would note then that even though CCPA is moving away to some extent from the traditional U.S. model, that notice and consent are still very central to the way CCPA operates. And so, Johnny, you want to talk about notice under GDPR?
Yeah, thanks, Jim. I'll probably do so slightly more briefly, because this is actually one of those areas where the GDPR, which has some strict requirements, but not so much in terms of notice, and certainly not so prescriptive. So for European lawyers, or those more familiar with the European regime, this is analogous basically to the requirement to send fair processing information or to provide fair processing information to data subjects. And under the GDPR, it's designed to achieve a similar thing, but the type of information that you need to provide is largely those types of information that you would expect to provide under any kind of transparency regime. It's what you're doing with the data, the reason you're collecting it or using it, who you may want to be sharing it with. It's that kind of thing. The kind of thing really that I think lots of businesses, if you were thinking, okay, well, if I'm looking at a good practice approach, I'd probably want to tell people this anyway. One or two slight wrinkles, points to draw out, is prior to the CCPA and other international laws taking a more prescriptive approach here, if we were advising global businesses or businesses that were looking perhaps to have an overarching privacy policy, overarching notice that would also satisfy the requirements of the GDPR, you would largely say, okay, well, it satisfies the transparency requirements, so you don't need to do anything, particularly kind of tricky here. Probably is worth bearing in mind that European law gives data subjects things like the right of access and various other rights, which we're going to be talking about at the moment under the consumer rights section. You maybe want to think about carving that out from the main policy and saying that this is just something that applies in relation to European subjects. So, for example, you are a global business, you think to yourself, well, we're caught by the GDPR because we are targeting European citizens, or we're selling goods and services to them. We've got a website that sells into the EU and it sells in euros, etc., etc. Perhaps it wouldn't necessarily be particularly helpful to invite your US customers who may not benefit from that right of access to be able to exercise those rights. So that's something to bear in mind, but potentially changing now that we've got things like the CCPA, which are taking a very similar, perhaps stricter approach. And then the last point to bear in mind in relation to the notice requirements under EU law is that it's a moving target. So, for example, under UK law, we are getting further regulatory guidance. We are getting further codes of practice that the regulators designed to bring in. One of those, for example, is known as the UK ICO's age-appropriate design code, which says this: if you're offering online goods and services to children, this is one of the things you bear in mind. That has notice requirements which are slightly more prescriptive. That will come into force in due course and will give extra food for thought.
Excellent. Thank you. Next point here on agreements with other entities. Under CCPA, there are basically three types of entities that are addressed. You have businesses that are directly subject to CCPA requirements. Then you have service providers who perform services for a business, but basically it's a little more complex than this, but it fundamentally can only use the personal information to perform those services. And then you have third parties, so entities that are not a business, not a service provider, but are receiving personal information from a business. CCPA requires there to be an agreement in place where a business is going to share personal information with either a service provider or a third party. Now, I would note that CCPA creates certain advantages to being deemed a service provider in terms of the oversight and the requirements that are applicable to you, but that necessarily then limits your ability to use personal information that you receive for your own purposes. Johnny, talk about agreements under GDPR.
Yeah, an interesting contrast here, and Joe, I'm going to deal with this one quite briefly as well, just in the interest of time. I was probably talked longer than I wanted to about notice requirements. So everybody well, lots of people are familiar with this requirement that the GDPR has, that where you engage a processor, which perhaps analogous to the service provider type entity under the CCPA, you need to have a written agreement in place. Comments to have there is everybody is familiar with these, because we saw in the run-up to and then after GDPR, lots of these agreements flying between different entities because GDPR is prescriptive as to what they say, and nobody had put these in place before the GDPR entered into force. Very prescriptive requirements you need to have in these written agreements. What we're seeing now is businesses taking a more sophisticated look at these agreements, how you paper that relationship. Because whereas previously people thought, well, it's a regulatory exercise, I just need to have something in place to satisfy the regulator. I don't really care what this part of the agreement says, the data processing terms. Now the regime's becoming more sophisticated. People are thinking about these issues further. People are now starting to think about liability, your exposure to contractual liability for a fine, for example, a monetary penalty notice that your contractual counterparty may receive. These kind of issues. So it's worth thinking about these contractual relationships further.
Okay. Thanks. How about consumer rights under GDPR?
Yeah, great. Yeah, if I kick off on this. So we've used this terminology here, consumer rights, which is perhaps more akin to the CCPA. So these are data subject or individual rights under the GDPR. There is a suite of them. Some of them are comparable to those under the CCPA. I just wanted to pick out one or two to talk about. And one of the key ones, which I thought would be quite useful to discuss, is what's known as the right of subject access under the GDPR, which obviously comparable to the CCPA, but it comes at comparable to the access right under the CCPA, but and very tricky to comply with, but for arguably different reasons. So a couple of points to make about that, the right of access. It's a very broad right that basically enables any individual without charge to contact the data controller and say, okay, if you're processing my data, I want certain information and I want you to provide me with a copy of that data, and you have to comply within 30 days. So different kind of time period to comply with that right. Now, the idea of providing certain information, things like how long you're going to be processing the data, the purposes for which you're processing, that's fairly easy to comply with. That's stuff which you've probably already satisfied in your notice, in complying with your notice requirements. But also this requirement to provide a copy with their data. So within the EU, certainly within the UK, this is a right which, when exercised, can be very time-consuming and complex for a business to comply with. And one of the reasons comparing it to the CCPA is there is no time limit. It can go back for as long as you've been processing data about those individuals. There is no cut-off for 12 months or anything like that. As long as you've been processing data about an individual, you will have to provide them with a copy of that data, which can be tricky to comply with. So when you receive one of these, the type of advice we give is to think about how long you've got to comply, and then think about how you can structure that search. So if you've got lots of different data sets about your business that may contain an individual's data, how are you going to structure that search in order to comply with this right within the time frame? I'm handing that back to you, Luke.
Thanks, Johnny. There are four primary areas of rights for California residents under CCPA. And if you want to see the best description of these, I think, is if you look at the draft regulations in section 308C. there's a right to know about personal information collected, disclosed, or sold. And this is somewhat similar to the notice rights and right of access that Johnny mentioned under GDPR, but probably a little bit more limited on the whole. There's a right to request deletion of personal information. This is probably the most analogous provision between GDPR and CCPA because it's very similar to the GDPR's right to be forgotten. And actually, we'll go into a little point on that in a moment. There's a right to opt out of the sale of personal information by a business, which isn't explicitly in GDPR, but I think there are other similar rights that might have a similar effect. And then there's a right to non-discrimination for the exercise of a consumer's privacy rights under CCPA, which is not explicit in GDPR, but it's probably implied there. And then just kind of quickly on the point of limitation of processing, there are limited ability. There's limited ability under CCPA to limit processing. You can limit sales. You can request deletion, but there's not a blanket right to limit use under CCPA like there is under GDPR. And Johnny?
Yes. So talking about this issue of limitation of processing, we mentioned the fact that the GDPR is a principles-based regime. One of these principles is this idea of purpose limitation. So you can only collect data for an explicit purpose. You should make that known to people before you'll collect the data, and you can't process it for further incompatible reasons. And this can be a restriction that fights and stops, for example, data sharing, businesses doing things with data which wasn't originally envisaged, and could be quite a limiting factor on how a business can use data. So the old kind of trite example that was given, that it would be difficult, for example, for a Google to have established itself in the EU under the GDPR, because Google was collecting all this information and then decided it was an advertising business. Couldn't do that under the GDPR. You need to think about what you're collecting the data for first.
Okay, thanks. So let's talk a little bit about enforcement. I'll pass it off to Luke.
Yeah. So on the CCPA side, I guess the short version of at least regulatory enforcement is work in progress. So the regulatory enforcement under the CCPA doesn't actually begin until July. There is a little bit of a lag period between the statute's effective date, which is January 1st of this year, and when the statute is actually going to be enforced by the Attorney General. Part of the reason of the lag time, obviously, it's a new statute. There's a lot of compliance obligations, and a lot of folks are scrambling to figure out what they mean. On a more practical level, the draft regulations are still pending. So part of the feature of the legislation was that the State Attorney General's office was tasked with implementing regulations, which are intended to give a little more detail into what's required to comply with the statute, and also give kind of a framework for what the regulations or what the regulatory enforcement is going to look like. So the first draft of those regulations came out late last year. There was a comment period. After the initial comment period, the Attorney General just a couple months ago came out earlier this year with some modified regulations. And then there was a second comment period that just ended at the end of February, and the final regulations are yet to be published. So it creates kind of an interesting scenario where enforcement is going to begin quite literally only a few months after the final regulations are published, if that. As you can imagine, a lot of the folks who submitted comments raised that issue, saying that we really, how do we prepare? The statute is actually technically already in effect, so how do we first comply with the statute, and two, prepare for enforcement where the regulations are still a work in progress, but that's the current timeline. So the regulatory enforcement for the CCPA is centralized with the California Attorney General's office. Again, it is a state-level statute, unlike the GDPR. and at this point subject to state level enforcement. Really the big takeaway there is, the Attorney General's office has many other things to do other than enforce the privacy statute, which isn't to say that this isn't going to be a priority. And in fact, the Attorney General himself in numerous public statements has said that he's going to prioritize bringing actions under the statute. That said, the resources available to actually bring Attorney General claims may not be that great, and it's yet to be seen. And I think in a prior public statement, he said something. The Attorney General Becerra, said something to the effect of he is looking at bringing a handful of these cases, 3, 4, 5 of these cases a year. The general expectation is going to be that the larger players, the social media companies, those types of folks are going to be an initial focus. And then I think there's also an expectation that it's going to be complaint-driven, because the Attorney General's office is going to be a little bit stretched in terms of resources of ferreting out violations. A lot of the enforcement that might happen, or a lot of the initial enforcement, might be the result of folks actually submitting specific complaints to the Attorney General's office, and that's how it's going to begin. But again, it hasn't started yet. It's expected to kick off right when statutorily authorized in July, and stay tuned. So, Johnny, how does that compare to I guess the more advanced state of regulatory enforcement in GDPR?
Yeah, no, probably an interesting contrast. So firstly, we talk about the AG, and I suppose the obvious equivalent here is the privacy regulator itself, the Information Commissioner's Office, of which the UK has the ICO. There are privacy regulators in each of the 28 member states of the EU, or 27 in the UK now. So there are lots of regulators, and they are fairly well equipped to take action if they need to do so. So the regulatory regime in the UK and the rest of the EU is pretty well developed, and you have a regulator that is prepared to take action. The regulators are certainly taking the approach that we are designed to educate businesses, not just to punish you, so that there is a carrot as well as a stick in there. But we're seeing regulatory action. They have a range of powers. They can issue information notices, enforcement notices, monetary penalty notice. They can fine you, and we're starting to see some of these fines take place already. A quick comment, because in some respects the concern or perhaps the hype around regulatory fines against penalty notices, it ebbs and flows, and we saw a real kind of ebb over the summer months when the ICO was looking to fine two major businesses, so one being the Marriott hotel chain and British Airways. We talked about these huge fines being potentially issued, 198 million and nearly 100 million for data breaches that they'd suffered. Just an update on that, we haven't yet seen those fines take place. The ICO agreed an extension until the 31st of March, when it gives those entities longer to consider their options and essentially appeal those fines. So we've not seen them yet. We are seeing other fairly large fines across the rest of Europe, however. So, for example, a good example being Google and the CNIL fining Google 50 million. So as you talk about some of these bigger entities, the European regulators are taking action against them.
Thank you. So on the private enforcement side, on the CCPA, this is actually one of the more interesting and certainly one of the more talked about features of the CCPA. There is a private right of action that allows private citizens to sue. It is currently limited to data breaches. So at this point, there was a proposal when the statute was kind of making its way through the legislature. There was a proposal, and actually afterwards, there was a proposed amendment to make the entirety of the statute privately actionable, such that consumers would be able to challenge such things as notice violations. The version that came out confers a private right of action only in the case of breached data. So consumers can sue companies based on unauthorized access to their information, resulting from, I guess, unreasonable security practices. Interestingly, the first couple lawsuits that have been filed under the CCPA have actually related to provisions or have actually related to alleged violations other than data breaches. Part of that is because data breaches are typically announced sometime after the fact, and a lot of the major data breaches that are kind of being talked about now happened in 2019 before the statute actually took effect. But it also shows really that the boundaries of the CCPA's private right of action are going to be tested right at the outset. So two of the lawsuits that were filed, one of them is a collection notice violation, which again is not supposed to be, at least under the plain language of the statute, is not supposed to be privately actionable. The other is pretty interesting too. The other pleads the CCPA violation as a violation of California's unfair competition law. So that's a law that allows you to bring a private claim based on violations of underlying statutes. There's actually a specific provision in the CCPA that, on its face, bars that use of the statute as well. The statute is not supposed to be used, at least again under I think a viable interpretation of the language. It's not supposed to be used as a borrowed claim to plead a UCL claim. But again, plaintiffs' lawyers are doing it, which I think shows that they're going to push the envelope, and it's going to be tested very quickly and I think very thoroughly in the courts. But even private litigation, it's begun, unlike regulatory enforcement, but it's still very much in the initial nascent phase. So how does that compare to GDPR?
Yeah, it's interesting. So under the GDPR, we are seeing a significant increase in the amount of private claims that are being brought. Me as a lawyer, we as a law firm, we're seeing these being taken against our clients. People are more willing to do so. There's been lots of speculation whether that's because the GDPR has just raised the profile of this and it's making it easier, so people are looking in an opportunistic way to claim. It's also relevant to bear in mind that under the GDPR you can claim more easily now than you certainly when you could in the past some time ago under the old regime, because you can claim for both material and non-material damage, essentially distress. And arguably following a case called Lloyd v. Google recently, perhaps even more widely than that, you may be able to claim just simply on the basis that your data was misused and you feel your data has an economic value and therefore it shouldn't be misused. So we are seeing more and more of these claims and likely to see a continued increase, a continued uptick as time goes on.
So the last bullet point on the slide is very briefly with respect to taking a reasonable and proportionate approach. On the CCPA side, I guess the short version of that, it hasn't been tested yet. So the statute in several respects addresses reasonableness and a reasonable approach, and that you can see that in for example, in verification procedures. You see that in the procedures designed to give adequate notice to consumers. There's definitely an overriding theme of be reasonable, and you certainly see that with respect to the private right of action, which again allows consumers to sue if their data is breached based on something other than reasonable security procedures and practices. The interesting thing, I think, about the CCPA in terms of reasonableness is certainly on the private litigant side, but even on the Attorney General side, assuming some of these regulatory actions wind up in court, is that ultimately it might well be a trier of facts that determines what reasonable or proportionate is. So certainly the Attorney General is going to have its views, certainly the company is going to have its views, and if the issue is litigated, ultimately it's going to be a judge or potentially a jury that's going to decide what reasonable security or practices might mean, which is, I think, a little bit different because, we have a whole number of frameworks, of applicable security frameworks, a kind of a menu of frameworks that companies are able to choose from and try to implement. But at the end of the day, it's going to be up to the trier of fact and really the lawyers to apply those to the facts and make the argument that it's reasonable or not, which is all a very long way of saying that there's no 100% sure standard to apply, and it's just we're going to have to carefully track what triers of fact are doing, what the Attorney General is saying, and it really is going to be a developing standard.
Yeah, and not a great deal to add on. I think it was very useful. Not a great deal really to add from the GDPR side of things. Maybe just one brief comment that when people are looking at an approach, and obviously businesses have spent a lot of time, money, and energy on this, and are definitely looking at taking a proportionate approach to compliance. That is absolutely the approach to take. When clients say to us, well, look, just the cost and the time involved, how am I ever going to do this? It's not going anywhere. You need to take some measures, even if you take that in a staged way. Not complying isn't an option, really.
Thanks, gentlemen. So what can we learn about CCPA compliance by looking at GDPR? As we've noted, there are some similarities, some differences. But because of these areas of overlap between the two standards, and given that GDPR is farther along in the development process, there are things that we might learn about CCPA there, particularly since there's a great need for interpretation of CCPA provisions, because it's been noted, compliance is expected before we may fully know what the requirements are. And so one area I'd like to particularly point to here is under the right to be forgotten in GDPR and the deletion right in CCPA. And I noted these are fairly parallel provisions in the two standards. And so the question has come up in Europe about what to do about personal data included in records where one part of them cannot be removed, such as in log files or backup files. What do you do if you get a request to delete that information? And this has been considered under GDPR in various ways. There was guidance issued by the French Data Protection Authority, the CNIL, where they said essentially where it's impossible or infeasible to delete information because it's in backups or log files, you don't necessarily need to delete it on a consumer request if you have a retention schedule that includes provides for deletion of those files at a set period of time, and then you explain that to the requesting data subject. And then there's somewhat similar language under a German derogation in the right to under Article 35 that talks about where deletion would be impossible or involve a disproportionate effort due to the specific mode of storage, and if the data subject's interest in erasure can be regarded as minimal. And then the UK ICO also has looked into this and noted that it may be that erasure requests can be instantly fulfilled in respect of certain live systems, but that the data will remain within the backup environment for a certain period of time until it is overwritten. The key issue is to put the backup data beyond use, even if it cannot be immediately overwritten. You must ensure that you do not use the data within the backup for any other purpose. So I think there are topics like this where you can look to what the EU has said, or the National Data Protection Authorities has said under some of these provisions of GDPR, because that might be something that California might look at, the California AGs might look at, or U.S. courts potentially could look at in interpreting these new CCPA requirements where they are similar. And I would note that there's no guarantee that they will follow the same approach, but they may follow a similar logic, and it may provide a way to justify what you may need to do in trying to comply with CCPA. Johnny, did you have anything along those lines you wanted to note? Or
Yeah, Jim, that's a really kind of interesting example, and there are others. I'd make one comment, just coming at this from another angle, really. And this is something which I sometimes talk about to the US lawyers who, when we contrast these two regimes, it's probably a topic we talked about between ourselves, which is the issue of privacy by design and by default under EU law, and particularly the requirements under EU law to undertake data protection impact assessments, which I don't think is something which you quite have a comparable example under the CCPA. And what I say when I talk about these, probably people who've heard me talk at other presentations this year, probably I'll be banging on about DPIAs again, is that I think these are a really useful tool. And the amount of times I've spoken to clients and assisted with data breaches and other infringements and thought, goodness me, if you'd only undertaken a DPIA, whether required to or not, this would have helped you. So what is it? Well, a data protection impact assessment is basically it's a risk analysis that requires you to go through the various steps of identifying risks and then the measures that can be taken to mitigate those risks. And whether you are looking strictly to comply with one particular regime or another, I'd encourage businesses to look at these. There's lots of examples on the European regulators' websites. The CNIL, to mention the French regulator again, has a good automated tool. They can be a very useful step in helping to comply with these kind of regimes.
Thanks. I would note, I mean, we're getting close to the top of the hour. We're going to run over a bit. We wanted to work through a scenario, which I think we can do, but just be aware we're probably going to run over the top of the hour in order to do that. A few other issues, I think, around CCPA or GDPR that are worth keeping in mind. One, this is a CCPA issue. CCPA came about because of a threat of a ballot initiative that would have been even more extensive, even more stringent. And so CCPA was drafted to head that off. But the person that spearheaded that original ballot initiative has suggested having a subsequent one that would grant additional rights beyond those in CCPA. So we could see additional pressure to add to the CCPA rights given to California consumers. And I think that's something to watch for in this next year or two. Luke, other states?
Yeah, other states. So as I said before, I mean, California is the first state to implement something like this, but certainly not the last. There are numerous other states working on various privacy legislation. Some of them are the various states are taking different approaches. The next impending one is most likely Washington. I think that one is the closest to being passed at this point, and that's Washington State, mirrors the CCPA in many respects. There is a current amendment that would make the entirety of it privately actionable, so that would be a significant difference, but otherwise, most of the consumer rights are the same. Other notable states that are working on something, Florida, Illinois, Florida, as well as a couple of other states, focus specifically on online merchants and website providers. But again, the approaches vary. Really the only thing to know for sure, or to recall for sure, is that more states are coming and probably in the range of 10 to 15 just this year, and hopefully they'll be similar enough to where you can blanket compliance, but that's not ensured.
And should I very briefly pick up this point of Brexit? So two key issues that when people talk about Brexit and data protection, which always come up. First one being in the near term, data flows. How is this going to be impacted? If, for example, you're a US business and you keep your data in Europe, but you also have a UK office, are you going to have to put additional measures to make transfers? Or will the UK receive an adequacy decision in the fairly short term, which would negate the requirement for these? A quick comment on there, which is it's not a very helpful answer. Who knows? We don't know whether the UK is going to obtain an adequacy decision. If you were looking at this purely through a legal prism, then the requirement being essential equivalence. Would you say, well, is the UK regime essentially equivalent to the EU? Yes, it is, but there are wider issues at play here. Obviously, it's a fairly politically charged area. And then the second issue, which people talk about in relation to Brexit, this is slightly kind of longer term, is may we see a divergence? Once again, talking as a lawyer, I don't want to kind of stray into politics at all, but the UK government has openly said that it is intending to develop separate and independent policies in areas such as data protection. So much as it wants adequacy, it is equally drawn that line in the sand saying, look, we're going to try and take advantage of Brexit, and if that means we need to make changes, well, we will make changes.
So on the next point of other regulatory and policy developments on the CCPA side, I think the biggest thing to look for, in addition to other state activities, is some sort of federal overarching policy, overarching movement. There are on the federal level a couple of competing bills, one proposed by the Democrats, one by the Republicans, have some of the same rights, certainly a lot of the same concepts as the CCPA, but would apply nationally. There's also a national proposal to develop and start a new agency, the Data Protection Agency, which would oversee a lot of the enforcement. In the meantime, the FTC is certainly pushing for more authority. That's the federal agencies pushing for more authority to enforce some of these issues because of some rather large sticking points between the Democratic and Republican proposals, including preemption and whether the statute is going to be privately actionable. There's certainly no guarantee that anything is going to be passed, and definitely no guarantee that anything is going to be passed this year. But certainly, overarching theme of more federal regulation is something to be on the lookout for.
Okay, thanks. And then this last point on possible CCPA effects on GDPR. As far as amending GDPR to account for some of the things that are addressed in CCPA, that seems unlikely, at least in the short to medium term, given the very long-term drafting structure that was employed under GDPR to begin with. But one area where we could see influence potentially, and speculating here, I admit, is on the opposite side of what I was talking about a moment ago. So some of these interpretations of similar provisions. This seems more likely. If we have interpretations in California around the sale of personal information, that could be examined by in Europe, where it's less explicitly regulated, as well as on one area where I think it's a little more comprehensively addressed is on the verification of data subject access requests. And I saw we had a question along these lines, and I would say there, look at the Attorney General's proposed regulations, because that's been a significant point in the drafting of those regulations. Is what do you need from someone to prove that they are who they say they are, or that their legal representative is who they say they are. So I think that is an area that could be influential on GDPR through what is done through CCPA. With that, we'll move on. I mean, I think we should quickly go through this very basic fact scenario we have here to illustrate some of these issues. So we have a company that's a maker of backpacks. They're based here in Chicago. They have employees and operations, but only here in Illinois. This company sells online and then through third-party stores. They have a website. The website is only in English, and it allows payment in a few different currencies, including dollars, euros, and pounds. And I would note this is a very common situation for many small to mid-sized businesses in the U.S. And then a few additional facts here. You can see they decided to sell sell information to a hiking boot manufacturer. They receive a request to delete personal information, and then they're in the process of being acquired by this other entity. Johnny, Luke, could you maybe think about some of these issues as they might be impacted by CCPA, GDPR, to kind of illustrate some of the scope and requirements of each standard?
Should I jump in first with a couple of points? And maybe we take some of these in turn. You know, that they're obviously having a bad week, BPI. There's a lot of stuff going on on the privacy side of things for them. But if we take in turn some of these issues that they're facing. So the first one, they decide to sell certain information to a hiking boot manufacturer, which obviously touches on data sharing. First point I'd ask, which is it's a question which both of us, both Luke and I, would be asking if we were advising these guys as the lawyer, is we'd be saying, okay, question whether the GDPR or the CCPA applies. GDPR likely does apply. If we look at that fact pattern, they've got a website, they're selling in euros. We talked about the GDPR's extraterritorial applicability. We talked about the targeting criterion, that goods and services. If you're selling goods and services, that's your connection to Europe, you're probably caught. So looking at the intention here, you know, why else would you be selling in euros if you weren't targeting Europe? So that's something to think about. Okay, so they want to sell information to a further business. Well, you'll be asking another GDPR, can you do so? What's your lawful basis? Have you thought about that? Is it consent? If it is consent, is that something that you have adequately obtained GDPR compliant consent in order to do so? Are you caught by the purpose limitation? Is this something which you envisaged at the outset, or is this a new processing activity and therefore you're limited there? Luke, I'll let you jump in and maybe chat about that in the next one. Or
Sure, and the good news is a lot of the questions, you know, when we're talking about overlap, a lot of the questions would be very similar for the CCPA. And the big distinction would be, you know, with the CCPA, you're looking at specifically California consumers data. So the first question would be, are you CCPA covered yourself, and that you need to run the company through the criteria of collecting information from California consumers, doing business in California, for-profit entity. Assuming all three of those check off, then you're looking at the revenue or the numbers to see if you're covered in the first place. If, for purposes of this example, you are a CCPA covered entity, then the next question would be very similar to what Johnny just described, which is, you know, what information is this? How did you get it? What notices were provided at the time of collection, including what the notice at the time of collection said you were going to do with respect to the data? That there is a provision in the regulations that basically says if you're going to do something different than what you disclosed you would do at the notice of collection, then you need to either do it again before you take new action with respect to the data, or you just don't do it. Because it at least appears to involve a sale of information, you need to think about opt-out rights. You need to make sure that if you are going to engage in a data sale, you're going to need to obviously analyze whether it is a sale of data depending on the circumstances. If you determine it is, you're going to need to make sure that a notice of opt-out was provided at the point of collection, and you're going to need to make sure that you're tracking any opt-outs that you received. If you did receive an opt-out, you need to make sure not to sell that information. So again, many of the same questions that would apply under GDPR, but the bottom line is you need to know how you got the data, what notices are provided at the point of collection, and whether if you determine it as a CCPA sale, whether you're authorized by the consumer to actually go ahead and sell it. And maybe let's move on, Johnny, to the deletion request. So what happens if they get a deletion request under GDPR?
Yeah, I think that's a good point in the interest of time. So jump into that one. What I'd say is we talked about subject access under the GDPR being a very wide right. When the GDPR came into force, people were talking about this idea of the right to be forgotten, which is the equivalent to a deletion request. under the GDPR. What I'd say there is you need to think about whether the deletion request, the erasure request, would actually apply in these circumstances, because it is a right that only arises in a fairly narrow circumstances, essentially, which is where you're relying on consent and consent has been withdrawn, or you no longer, the data is no longer being processed for the purpose for which it was collected. Those are the only circumstances in which that applies. If that applies to why you're keeping the data, then of course you'll delete it. Is that likely to be the case in relation to a business that perhaps is processing the data of a consumer that have purchased goods from it? You might have various regulatory reasons for withholding, for keeping hold of their account details. You might have internal audit things. You might be basically processing their data for a lot of reasons other than consent. So to not necessarily become too concerned, but think about how you're going to respond to this and think about whether you can back this request away.
Thank you. And again, good news is on the CCPA side, a lot of these same questions, a lot of the same considerations. If you get a deletion request under the CCPA, the first thing you need to think about is verification and timelines. You need to think about you have 10 days to respond to the thing, at least initially, and you need to start the process of verifying that the person making the request is actually who he or she says she is. So once you've cleared that, the similarity with the GDPR is that there's a whole category, a whole list of exemptions to a deletion request. There are actually 9 separate exemptions, including some pretty broad catch-all exemptions, such as the last one, which is you're not required to delete information in response to such a request if you're using the information in a lawful manner compatible with the context in which the consumer provided it. So again, very broad language. You can probably craft some sort of argument why you should be required or why you should be able to keep the data. The first step would be, after you've cleared verification, look through those categories and see if there's any legitimate basis, assuming that you want to keep it, assuming that it actually is necessary for you to do, because there are obviously data hygiene issues. Maybe you just want to delete it. But go through those categories, and then the one, I guess, distinction would be that under the regulations, if you're going to decline a deletion request, you need to explain to the consumer making the request why you made that decision. And it's not crystal clear at this point, the level of detail that you need to provide, but it is clear that you need to provide some sort of explanation, including the baseline explanation that you're not complying with the request, so the consumer is made aware. So what about the last one of the acquisition?
Yeah, so from a GDPR perspective, actually this one is fairly straightforward. If this is genuinely a share sale, the data control will remain the same. There's no real difference. The question, if this was an asset sale, for example, would that be different? Yes, it would. A change of data controller, and then you're back to some of those issues that we were asking about before. Okay, well, if the control is changing, well, essentially that is a transfer of data to a third party. What's your lawful basis for processing? Is one of the things you're doing, for example, sending direct marketing, where you are limited to relying on consent? Is that going to be impacted? These are some of the issues that you're thinking about under the GDPR in the context of an acquisition.
Thank you. And again, quite a bit of overlap under the CCPA. There's a specific provision of the CCPA that exempts from the definition of sale the transfer of information that's part of a merger, acquisition, or other transaction where the third party assumes control of all or part of the business. So it's a exemption specifically designed for these types of situations where there's a change in the company. The one thing to think about there is, number one, you need to make sure that the transaction documents accurately reflect that. So that if you acknowledge that you have personal information that you're transferring, that somewhere in your deal documentation you've actually identified the information that this specific exemption applies to, so that there's no question of whether particular information was necessary or part of or deemed an asset as part of the sale. Just something to think about. And then the other thing to think about is there is a limitation. If the sale involves, or if the transfer of control to the new entity involves the new entity doing things with the data that the old entity did not. If and notice of that was not provided, you might need to take a look at your initial notice of collection provisions. And again, make sure that post-merger, post-transfer, post-asset sale, the information that you're, the reasons that your purposes that you of use are consistent. Otherwise, you might need to revise your notice provision and do it again.
Okay. Thanks, everyone. I'm sorry we did go a bit over. Thanks for participating in the webinar. Please complete and submit the survey that'll display at the end here. We did get several questions about logging out, people who had to go to meetings. Clearly, if you did, you're no longer here, but if you have colleagues that needed to do that, it's all automatically tracked, so I don't think it should be a problem if somebody had to leave prior to now. It would note that you were here for the full hour. But thanks again for attending, and we'll continue to have updates on CCPA as well as other requirements going forward in the privacy and security space. Thanks again to everyone.
Thank you.
Thank you.